of the Republic of Mozambique and various as nationalities.
Yes, Mr Matthews.
Good morning, my lord. May it please your lordship, I appear together with Mr Frederick Wilmot-Smith for the appellant, and I shall refer to them as Privinvest to encompass the corporate defendants and my late client, Mr Iskandar Safar. Your lordships have, I hope, seen the order that Mr Justice Knowles made for representation of Mr Safar.
Yeah, the order made yesterday.
Indeed, my lord, I hope your lordship's seen that, and is content to proceed in the circumstances with that order in place. There's a slightly unusual proviso in that order that anybody is entitled to apply without change of circumstances. That was to address the urgency of the matter. Nobody, to our knowledge, has yet indicated any intention to apply, and therefore...
Well, we'll proceed on the basis that that order is in force unless somebody tells us it isn't.
I'm very grateful, my lord. And my learned friends, Mr Rodney Dixon, King's Counsel, and Mr Russell Hopkins, appear on behalf of the respondent. This is my client's appeal against the order of Mr Justice Knowles, which your lordships have in the core bundle at tab 3, in which he overturned the decision of Mrs Justice Cockrell, granting permission to my clients to serve the respondent out of the jurisdiction in Mozambique, and the appeal is brought with permission from Lady Justice Lang, which your lordships have in the core bundle tab 9. And your lordships have, I hope, a core bundle of documents and a supplemental bundle of documents, and authorities bundles divided, if your lordship has them in hard copy, into 4 separate bundles. I will proceed, my lords, on the basis your lordships have read the skeletons in the core at tabs 12 and 13, the grounds in the core at tab 2, and the respondent's additional reasons, or the respondent's notice, in the core at tab 11.
Yes.
As a matter of timing, I haven't had the opportunity to discuss this with my learned friend, but we have up to 1.5 days, 7.5 hours, 3 3/4 hours each side. I was going to propose 50-50.
It seems to us that that was perhaps on the generous side, given the issues.
Very good, my lord. Well, I'll move on.
I'm not. We won't stop you from taking a day and a half with it, but it did seem to us it might be possible to deal with the case in slightly truncated time.
Well, I certainly intend to deal with part of that the case in that way, and I shall be as swift as convenient. I was going first to address the question of whether President Nyusi was served on the 19th of October 2021. If we are right about that, then the President is out of time for this jurisdiction challenge.
Just on logistics, Mr Matthews, we have got transcript, haven't we?
Yes, my lord, we have not a live note, but end of day.
Yeah, that's fine. Just so I know, so we don't have to take as detailed a note as we might have.
Won't be word for word, my lord. Which you'll be relieved to know. Yes, there is that backup.
Yeah.
So if we're right about the 19th of October 2021, then the respondent is out of time for this jurisdiction challenge, and that is the end of the matter. And I was then going to come on secondly to deal with what one might refer to as the battle between the now Master of the Rolls and now Lord Briggs, as to whether there should be a geographical limitation on the exception to sovereign immunity for the...
That only arises if there wasn't good service in 2021.
Correct. And it did not, in the event, seem necessary or appropriate to trouble the court with a supplementary skeleton on the respondent's notice. But I shall pick up the various points we make on the respondent's notice as I go through the main substance of the appeal or in reply if they're persisted in, and I hope that's convenient. The President respondent, of course, was central to the issues which have been the subject of a trial the whole of last autumn in front of Mr Justice Knowles.
Yes.
But he was central to them essentially in his capacity as Minister of Defence at the time, And just to give your lordships a little bit of context, he was Minister of Defence at the time when this whole project was conceived. He lay at the heart and centre of it. It consisted of, as your lordship has seen from the judgment, 3 supply transactions between Republic SPVs and various of my clients, corporate entities. Those agreements provided for payment to my clients. That payment was achieved by means of bank loans received by the SPVs from various banks. Those loans to the SPVs were backed by sovereign guarantees, and it is the battle between principally the Republic and the banks which occupied the autumn in relation to whether the sovereign guarantees were effective and could be called on, and my clients were there because the Republic was alleging that the circumstances in which the transactions were entered into were corrupt and entitled them in those circumstances not to honour the obligations. And the role of there were allegations as to secrecy, as to the payment of money, and all of those matters were, we say, and have said in that trial, matters within the knowledge of the respondent, who was at the heart of this whole exercise in setting up this arrangement. He then ceased to be Minister of Defence and stood for the office of President, backed by the ruling party Frelimo in Mozambique, and he was duly elected in early 2015 as President. And so the position is that despite best efforts, it was not possible for my clients or indeed anybody else to obtain the presence and participation of President Nyusi to address the many issues that arose in the autumn relating to his role, and nor did the Republic call him as a witness, and nor, of course, has the Republic waived his immunity, it being, of course, the Republic's immunity in effect that he asserts, and it is the Republic's to waive, but they have not done so. Turning then to service on the 19th of October 2021, my clients applied for and were granted by Mrs Justice Cockrell permission to serve out, and it's just worth having that well in mind. That's in the supplementary bundle at tab 6. And the key elements of that are on page 199 of the bundle. In paragraph 1, the permission was given to serve out, and in paragraph 2, including the error referring to 6.15, I'll come back to that, but it's not of any significance. 6.36, 37 and 38, the applicants have permission to effect the service referred to in paragraph 1, either by direct service in accordance with 6.42(3)(a) at the palace, which is the residence, or the office of the President, or elsewhere in Mozambique, a relatively standard clause identifying that there are places within Mozambique at which the respondent could expect to be found, and permission given generally to serve, identifying some specific places or elsewhere in Mozambique. And secondly, by service through methods other than through diplomatic channels, as permitted under Mozambican law and CPR 6.43c. And I'll come back to that separately, but we are not directly concerned with that aspect of it. It is subparagraph A that we are predominantly concerned with, though in discussing some of the questions of construction of the rules, the question of permission under 6.43c also becomes relevant.
One of the things that we discussed before coming into court was this order. As my Lord Justice Phillips pointed out, with more recent experience of sitting in the commercial court, an order in that form is actually quite unusual, because normally you just get permission to serve out of the jurisdiction in Mozambique, and effectively it's left to the party as to how service takes place in accordance with the rules. It's quite unusual to define direct service on the President at the palace.
That may be a difference of experience, and of course I bow to the superior experience of my lord. It's certainly been my experience over some decades.
You would say that's what you did.
Well, we would say that's what we did, but I just make it clear that I'm not relying. It is not suggested that we got alternative permission to serve out.
No, I understand that the reference to alternative service is a mistake.
So I still have to justify that we properly served in accordance with the order.
The thing is, though, that whilst you normally provide permission to serve out, and you might say where within Mozambique, what you don't normally do is give permission to serve by a particular route under the rules, because for the whole argument here is it's being said that, well, that route doesn't work, but the judge has given permission to serve under that route. Well, what's the effect of that?
May I come on to deal with that in the context of dealing with the various bits, because I would still be stuck, as it were, with the 6.44 rule if it's contrary to Mozambican law. And it is being said that this is contrary to Mozambican law, though I'll come back to say that there's no evidence of that. So I'd be limited by that. I hesitate to take advantage of this in this sense, that it is identifying places where, derived from the evidence, it is expected that the President can reasonably be found.
But it's more than that. It's actually specifying the route. 642(3)(a). And a judge undoubtedly does have the power to grant permission to serve by any route. They've got jurisdiction to do so.
The court must have the power to order any route permitted by the rules or alternative service. If it's not a route permitted by the rules, it would have to satisfy the requirements of alternative service for the court to have the power to do that.
Yes. And here it says, pursuant to CPR 650. On the face of the order, it seems to be a quite clear permission to effect direct service.
Whatever that means.
In the way in which you say it was effected.
Well, yes,
Sorry, no, go on, Mr.
I was simply going to say, my lord, that the power to make that order was not requested under 6.15, and it would be wrong of me to seek to take advantage of that. I accept that it was not intended, and the judge clearly in terms stated at the hearing that she was not at that hearing giving permission to serve by alternative means under 6.15, but that the door was open to do so. If we wish to do so, we could come back to get that permission. So I could not fairly say.
I don't want to push you into arguing something you don't want to argue, but on the face of what's happened here, there was service in accordance with an express order of the court, and there was no application under Part 11 to set it aside.
Well,
so on the face of it, I can't really see what the counter to it is. But unless you make the concessions, it seems you'll make.
The basis of your concession, which is that effectively this was simply a mistake in the order, because you say, and I'm sure assuming I haven't been through the transcript, A, it was never asked for in the supporting affidavit on the basis of alternative service. B, at the hearing, it wasn't asked for on that basis. Indeed, the judge said she wasn't doing it. So it clearly is, if that can be made good if necessary, but it clearly is a slip, and I therefore see why you shouldn't. Do you know, by the way, how it got in? It was just somebody drafting user on precedent or something.
We asked for alternative service by a whole raft of different routes, including email addresses that the
But how-
respondent regularly used, and I'm afraid
How did it get into the?
That wasn't permitted, was it?
and that wasn't permitted, and I cannot
Because it
say.
wouldn't normally be permitted unless you had evidence that you tried to, I mean, normally you try to serve in accordance with one of the methods of service, can't do so, and then apply for alternative service.
And that is why Mrs. Justice Cockerell very properly said, the door is open if you come back and have difficulties by these methods. But we still have the difficulty of having come to,
Yeah.
to go back under 6.15, and I cannot properly say that we got permission under 6.15 or that we got alternative service. Mrs. Justice Cockerell did not grant it to me, and so I cannot claim that advantage, as it were, fairly. That would not be right. So we have the order, and although very attractive as simply saying, well, we serve in accordance with the order, I do say, and I'm content to defend on the basis that the order was properly made in accordance with the rules and without reference to alternative service.
No. Okay.
Can I just ask one other procedural thing while we're here? What is the act? What was the process by which it came in front of Mr Justice Robin Knowles for decision? So there's a reference to an application in his order, but I don't think we've got it.
There was what occurred in 2023 was finally service through the Mozambican system.
What I see that. Sorry, I'm just asking for a purely factual question. If you look at the order, page 23 in the call bundle, order is made on the fourth party's application, dated the 16th of June. And I just wanted to follow up the chain, the procedural chain, to see that application. It doesn't appear to be in the bundle, or if it is, I've missed it, and someone can tell me where it is.
I don't think it is.
No.
It's the application itself is not in the bundle.
Nothing probably is to tell on it, but I think for form's sake, speak to myself, I'd like to see it.
That would be sensible, but yes, I apologise for that. Yes.
Yeah.
An abundance of effort to reduce the size of the bundle rather than to increase it, I'm sorry, but we will remedy that by making available to your lordships copies of that application. Because as your lordship appreciates, what happened is that despite, we say, the service in October of 2021, it took an inordinately long time for the Mozambican judicial authorities to be able to find a convenient date in the President's diary when service could be effected upon him by the court through the alternative, shouldn't use the word alternative, by the other means, namely service through diplomatic channels. But one of the happy byproducts of the coronation was that very shortly before the coronation, suddenly there was a gap in the President's diary, and he accepted service and challenged, and then came to London for the coronation and the heads of Commonwealth government meeting that took place there. So a happy outcome in that respect. So we have that basis, and that is what triggers the the third ground of appeal, which is the Sovereign Immunity Act point. Because of course, if we are wrong about our first two grounds, then the third arises as to whether in fact
there's no dispute that he was served properly in 2023.
Exactly, my lord.
Your point is simply that if he was served in 2021, he's out of time to take the sovereign immunity point.
Precisely, my lord. And I'm not going to go through all the points, many of which we've dealt with in our skeleton. I know your lordships will have taken them. I'm going to do with one or two points which are either in the respondent's notice, points about, for example, section 1(2) of the Sovereign Immunity Act, suggesting that in effect seems to be saying your lordships have to take this sort of almost of your own motion and de novo, and I'll take your lordships to the Zhongshan case in relation to that, which two of your lordships will be extremely familiar anyway. But I'll come back to that. But if we're right about the first method of service, the respondent's jurisdiction challenge must fail. He's out of time. We put that in our skeleton at 17 subparagraph 6. It doesn't appear to be challenged, and it was not otherwise contended below. As your lordships have seen, and we've just addressed, reason 6 of the respondent's notice addresses the alternative service point, and I think I've now fully covered that to deal with that. So turning to ground 1, we cover that in detail in our skeleton argument at paragraphs 17 to 35. I just really want to explore with the court, because it's slightly fiddly, how it all fits together and why we say it all works. The first of the permitted methods was direct service in accordance with Rule 642(3)(a), and that...
Now, have we got that in the authorities bundle?
No, my lord, I'm sorry.
Bizarrely, the most important thing we have to look at wasn't in the authorities bundle.
I'm sorry, my lord.
The position is this, that for reasons I won't elaborate in court, we no longer have white books in
Oh,
court.
I'm sorry, my lord.
I did have an out-of-date white book here in my court until I think 2 weeks ago, but it seems to have disappeared. We don't have the current white book, and it doesn't seem to be in the bundle.
I'm so sorry, my lord. I'm very gratefully assisted by my learned friend, who appears to have just run up some copies for your lordship.
Well, speaking for myself, I printed it all out last night.
I'm very
But even
grateful. I
if it had been-
apologise for your
even if
lordship.
you had thought that, oh, well, it's all right because I'll have the white book,
Yes,
you need something you can write on, so...
I follow, my lord. I apologise. Sorry for that.
That's very helpful. Should we put that in the back of bundle 4?
Perhaps it could go into the fourth authority bundle at the back of tab 33.
Yeah. You seem to have got
It
one
won't have a
page.
This is
pagination.
particularly unusual in that we have got, when I turned to this, I thought, oh great, they put in everything. We got the first page, which just says what all the rules are, and then we haven't got the rules
Yes,
themselves.
that was not helpful. I apologise, my lord.
Anyway,
Right, okay.
this.
Right, so what are we looking at?
So
Mr.
if we
Matthews?
can start, my lord, and I'm, in my generosity, I gave up all the copies. I'm hoping one of them will come back to me, and then I will be able to guide your lordships through the
Well,
pagination.
you can have mine because...
No, my lord, it's coming back here, so it's fine. But the first thing I wanted to refer your lordships to was 6.42(3)(a), which your lordship should have at pages 16 to 17 of this bundle.
So any Commonwealth country which is not a signatory of the Hague Convention.
Which includes Mozambique. So where a party wishes to serve a claim form or other document in any Commonwealth state which Mozambique is, which is not a party to the Hague Convention, or which, again, Mozambique is not a party to the Hague Convention, then the methods of service permitted by paragraphs 1b and 2 are not available, and the party or the party's agent must effect service direct unless practice direction 6b provides otherwise. Now, I'm going to deal, ground 1 is the first part of that. Ground 2, if it arises, is the second part. There is, in our respectful submission, a question mark over whether the judge actually dealt with the second bit as a ground at all. But we deal with it anyway for completeness. So what we say is that direct service under 42
Sorry to be pedantic, but it says service direct.
sorry, my lord, service direct.
There is a point by making that point, but we'll wait and see how we go.
Very good, my lord. And in relation to that, the position is, and if I can just sort of track it through, if we start with how we get there, as it were, if we go back to Rule 640, subparagraph 3A, on the previous page, your lordship sees that where a party wishes to serve a claim form or other document on a party out of the United Kingdom, it may be served by any method provided for by Roman 2, Rule 6.42. So that's how we lead into 6.42. There's also, as your lordships will be aware, and I'll come back to that in a slightly different context, under 40 paragraph 3C, any other method permitted by the law of the country in which it is to be served. And so 43A 2, Roman 2, directs us to Rule 42. Within Rule 42, we get to 43A, and that is service direct. And we say that service direct means any of the methods provided for in Rule 6.3, 6.9, which can be satisfied. And we get that, we say, not only because that is the ordinary and sensible meaning of it, but also because we say Mr Justice Richard Jacobs correctly came to that view in the FBN Bank case.
Just before we get there,
Yes.
Surely the natural reading of the phrase must effect service direct. Direct is simply an alternative to through. The structure of 642, the title is service through foreign governments, etc. Then various alternatives, all of which are through 642.1a, through the authority, under convention, 642.1b, through the judicial authorities, through a British consular authority, and so on. And service direct simply means service otherwise than through any of the means provided in the earlier subparagraphs of the rule. Now that may in the end come back, you say, to direct service as we tend to use it about 6.3 and so on. But that's not the sense in which it is being used there, is it? It's simply being used service direct as opposed to through any of the people identified above.
It is correct that it is direct as opposed to through any of those means, but if you then ask yourself what is service direct, the methods are identified elsewhere in the White Book as to how you achieve service direct.
Well, that may be so, but that's the exercise we have to go through. It's not simply a shorthand for direct service. It actually ought to be an adjective, it ought to be an adverb, it ought to be service directly, I think, but it's clear that that's what it means. But anyway, I put that to you and I hear what you say.
The problem with this part of the argument is that some of the rules in 6.3 to 6.9 just don't seem apposite in these circumstances.
If they're inapposite, then
I mean, the obvious example is 6.7, which is service on a solicitor nominated by a partner. I mean, obviously, if the president had nominated a solicitor for service within the jurisdiction, you wouldn't actually need to go through any of this rigmarole, if I put it that way. You'd simply serve under 6.7.
yes, but that doesn't limit the circumstances or the application of those methods which are available.
Service on a solicitor, service direct.
I'm sorry, my lord.
Why is service on a solicitor service direct? I mean, I can follow the point that personal service may be service direct, and I suppose service by post may be service direct. It's a very odd. I mean, the service direct point arises in the context of that part of the rules which deals with service out of the jurisdiction. And yet there's nothing in the rules to indicate what's meant by that phrase.
There's nothing that we're aware of, my lord, yes, we're not
I
able
think
to.
I mean, it's common ground, there's nothing.
Yes. And so we suggest that the approach which Mr Justice Richard Jacobs took in the FBN bank case is the natural and ordinary, and
Where do we have that?
that we have in the Authorities Bundle 3, tab 22.
Yeah.
And the point is taken by my learned friend that the defendant was not present and was unrepresented, and therefore the criticism is made that it was not fully argued. So one can assume that it was both sides of the argument presented by Mr Shah. And your lordship see from page 724 of the bundle that it was an application for summary judgment. And as a prelude to being able to give summary judgment, his lordship had to be satisfied that the defendant had had an opportunity to participate and that the claim had been validly served. And he concluded at paragraph 4 that it had been validly served. And then he comes on at paragraph 7 to deal in a little more detail with the requirements of service governed by part 6. Permission to serve out was not required because there was a contractual agreement which gave the English court exclusive jurisdiction. So the only difference of that case, and it's not a material difference, is that there wasn't an application for permission to serve out. There was service out because no permission was needed. And the question arises is, how do you go about serving the defendant? And the starting point for that in the context of serving a claim form outside the jurisdiction is CPR 6.40. Under that, there are a number of ways in which it can be served. One of the methods is in accordance with 42, and that is the effect of 43 Roman 2, which we've looked at. And the other one is one we'll come back to, the any other method permitted. And the claimants in this case rely upon both 6.42 and any other method permitted by Ghanaian law, and that has a relevance in a slightly different context. He starts with 6.42 though, expressly referred to in 6.40, and it applies to Ghana. It's similar to Mozambique, a Commonwealth country, but not party to the Hague Convention. And the provision that we've looked at, and the claimant was required and indeed were entitled to serve direct. In other words, not through judicial or consular authorities as provided for earlier in 6.42. And so the question is, what does that mean? And Ms. Shah is correct in her submission that in order to understand service direct, one can and should look at other provisions of the CPR dealing with service. One of the provisions is 6.5, which is how they can be served personally. And then in addition, paragraph 12, CPR 6.9 provides a set of rules which are applicable where the personal service rules do not apply and the claimant does not wish to effect personal service under 6.52. The position here is that the claim form must be served on the defendant.
6.52, isn't it?
6.5.2, Lord, yes.
52, yeah.
At a place shown in the table set out in 6.92. And then it goes on to deal with the case of a foreign company, but we say that it's equally applicable with the case of an individual. But obviously the relevant provisions apply to according to what is permitted in relation to an individual rather than a business. And those are to be found in CPR 6.3, various ways a claim form can be served, including personal service, first-class post, and leaving it at a place specified in one of those matters. So that's the structure of the CPR, and with respect we would adopt that. And at 14, as far as English law service is concerned, by which I mean service coming within CPR 6.42, it seems to me that there has in this case clearly been service which has been direct, and His Lordship finds that it was effected in various ways. And over the top of the next page, he finds in relation to 6.3 that there's been personal service by leaving it at a place specified in 6.9, which again, by analogy for an individual, would be principal place of residence, which on any view would be the presidential palace. And paragraph 15, that seems to be sufficient. There are also other steps, and he goes into dealing with service by post, which again he accepts and acknowledges as an acceptable method of doing so. And he analyses the matter, paragraph 16, that it was posted to a number of addresses, and that he says in the last 3 lines of 16 is an appropriate method of service provided for in 6.3, and the relevant addresses are those, and so on. And then at paragraph 18, his lordship says he finds the documents were hand-delivered, and that again would qualify as service, this time under 6.5. And then at 19, he says, well, I've dealt with 6.42. As I indicated, it's permissible in addition, and this is all important for when we come on to look at the 6.40 sub-rule 4 and the interplay with 6.40 sub-rule 3, to serve any other method permitted by the law of the country in which it is to be served. And then he looks at the provisions of Ghanaian law and considers how that can be achieved, and concludes at the end of paragraphs 23 and 24 that therefore the relevant service has taken place as required. And then the rest of the judgment deals with the summary judgment aspect. And we respectfully submit that that is a perfectly legitimate, sensible and appropriate analysis of the application of 6.42(3) as to the service direct requirement, and that gives meaning to it. It cannot mean simply service as permitted by local law, because that is already included in 6.43(c) as a method permitted. So if service direct simply meant the same as 6.40 rule 3(c), then that would be OTOs, which seems...
Does that follow? All it's saying is that where none of 642 through various parties applies, you've got to go back to serving someone not through someone else, not through the authorities, and you must look, as you rightly say, elsewhere in the rules to see where you can do that. And one obvious place is 640C, because these are the rules about service outside the jurisdiction.
Well, the trouble with that is, first of all, that's not what it says.
Well, it is what it says.
Which it could. It doesn't refer back to that method of service. It doesn't say service direct as permitted by the foreign law. And if you go back to 6.43 A and B, those would both be methods through which, or through authorities, by which service can be effected. And so C is available anyway. So it doesn't make any sense to say, if you're not going by 3A or B, then you can go by, well, as I say, it doesn't actually specify what, but you'd be back to C, but C is there anyway. So you don't need the provision in 6.42 to give you the provision in 6.43C, because that's already in place.
Well, it's just spelling out the consequences of 1B and 2 not being available.
But that would implicitly suggest that service direct means any method permitted by a foreign court, by foreign law. But why should that be referred to as service direct?
Well, direct means as opposed to through anyone else.
Well, but that begs the question as to whether service methods permitted by court but by the laws of the foreign state, are methods that are limited to having to serve on that person, rather than there being other means by which service can be achieved.
Well,
So it's not a happy phrase to use if it's intended to apply to the simply to the foreign law methods of service, which may or may not properly be referred to as direct, depending upon what they are. And so, in our submission, that can't be the right interpretation. And Mr. Justice Richard Jacobs' approach is the better interpretation of that, namely that you're back to the methodologies permitted under English law. And the reason for that is the perfectly sound one. And it is, in a sense, linked into, and I'll come back to it, the 6.44, subparagraph 4, which says nothing in this authorises or requires a person to do anything which is contrary to the law of the country where the claim form or other document is to be served, which is a much more permissive rule than simply methods which are permitted by the foreign court.
Am I right in thinking that the structure of the rules here, 640 is general provisions about the method of service of a claim form or other document on a party out of the jurisdiction.
Yes.
And then we can ignore 642 because that's elsewhere in the UK. So effectively, what we have at 643 is the general rules about the method of service of a claim form on a party outside the UK. And is this not a comprehensive scheme? Is it not intended to be a comprehensive scheme? That's what it reads like.
Well, the provisions generally are intended to be comprehensive in the sense that absent 6.15, which is obviously outside this, you have to comply with the methods in 6.40. But I mean, 6.15 is a classic example of a procedure by which you can serve out of the jurisdiction other than within one of the methods in 6.40, provided that, nevertheless, any order made under 6.40.15 must not be contrary to the law of the country. But there's no doubt that it doesn't have to be one permitted by the law of the country. So the whole regime of 6.15 would not fit within 6.40 if that were the complete code. So it's clear it goes beyond that.
As I read it, 43A 2 provides for a particular form of service, 6 as provided in 642, and 3C is any other method permitted. So it is a method other than that provided for in 642, which would suggest that service direct is not referring to that provided for in 3C.
Well, any other method could be any method beyond those identified above, as it were, which would include the route through 6.42, which would include...
My understanding is that 642 is dealing with situations where, because they are parties to civil procedure conventions or treaties, you must serve it through the mechanics of those treaties. And then it ends up by saying, if none of those apply, then you must serve direct. You may serve direct.
Yes, in relation to a specific category of countries identified in 42.3a, b and c, namely Commonwealth states, not party to the Hague Convention, Isle of Man or the Channel Islands, and any British overseas territory. And in relation to those specific countries, and only those countries, you are permitted, if because the other methods don't apply, to serve direct. And that, we say, correctly analysed by Mr Justice Richard Jacobs, takes you back to the methods of service that you would adopt in England under those rules that he looks at. It would also potentially be obviously any other permitted method by the law of the country in which it is to be served, but the restricting factor is 6.44, that you can't do something by virtue of 6.42(3) or any other provision which would be specifically contrary to or illegal under the law of the foreign country. And so in that sense, 6.40, well, in the 6.15 sense, it can't be a complete code because there are other provisions which provide methods of service which are not encompassed within this. But also it is the sort of guide, in a sense, to where you go for the various different methods of service.
I mean, leave aside the 615 point, which I follow. So as you rightly say, it can't be a complete code because 615 provides for alternative service. But where you haven't applied for alternative service, you're just going down the service out route, if I put it that way. Then doesn't it work? I mean, it's abominably drafted, but isn't it basically saying that so far as 640 is the general provision, and you've got either 640, leave aside 644 about states, but 642, which in brackets in 640 A Roman 2 only actually refers to service through foreign governments, judicial authorities and British consular authorities. But 642 also includes 642(3), which we're on here.
Yes.
So although it's a bit cack-handed, 642 would encompass the route that you're seeking to adopt here.
Yes.
Service direct. And then in addition to that, you've got, because B by definition isn't applicable because there is no civil procedure convention or treaty.
Yes.
You've got any other method permitted by the law of Mozambique in C, which it might be. I don't know. I mean, it's difficult to think what method that might be, but there might be something that isn't covered by service direct, I think.
Well, yes, and I mean, there are some interesting provisions in Mr Justice Richard Jacobs' case in the Ghanaian law. There are various provisions there which would permit forms of service that, absent an order for an alternative service, probably wouldn't be permitted under English law. And so there's no doubt that different countries obviously have different rules, and some are wider and some are narrower than the rules that we operate.
Yeah.
But what the 6.42 specifically does in relation to, as I say, there's three limited category of countries.
Yes.
Commonwealth countries not party to the Hague Convention, Isle of Man or Channel Islands, and any British overseas territory is to permit direct a service direct. And we say, correctly identified by Mr Justice Richard Jacobs, that means the methods that would otherwise be adopted, unless, of course, 40 subparagraph 4, that would be contrary to the law of those receiving states. So that's excluded. But it is ultimately perhaps not that surprising that there should be adopted methods of service on British overseas territories, the Isle of Man, the Channel Islands.
Well, I was about to say, if one just focuses on that, the Isle of Man and the Channel Islands, then one can see the force of the point. Service direct is most likely to mean some form of personal service or service by first-class post or whatever, on what are effectively adjuncts, if I can put it that way, of the mainland.
Yeah.
You wouldn't expect it to have some sort of unduly complicated further requirement for service in the Isle of Man or the Channel Islands.
No, and obviously the Commonwealth has grown, countries have accreted to it, such as it happens, Mozambique and I think Ghana, that were not. Sorry.
Ghana always was.
Ghana
The
was
obvious example is Rwanda.
Ghana was a British.
Mozambique and Uganda No, Rwanda. I'll get there.
Rwanda
Yeah,
has a
sorry.
Belgian background. Portuguese, Mozambique has a Portuguese background.
Mozambique was a Portuguese colony, but it became, on independence, or soon thereafter, it became a member of the Commonwealth.
And so clearly the scope of that provision is broadening in that sense, but one can appreciate why the approach to it would have been along the lines of, well, within these limited category of countries, methods of service that the English courts have identified will operate unless those countries have legislated against them. And that's perfectly legitimate. They have their sovereign independence. They can legislate independently for different routes, better, or in which case it's caught by service methods permitted by those laws, or more restrictive, in which case it's caught by methods contrary to that.
Can I just throw one other thing into the analysis? Everyone is agreed that 615, i.e. alternative service, is available in the case of service overseas.
Yes.
But that's not self-evident when you look at the structure of the rules, because, as I've suggested to you, 640 appears to give a comprehensive regime. And that troubled the court in Abela. Well, not so much troubled it, but they felt it had to be explained. And they found a particular answer to it in 637.5, which annoyingly we haven't got, but we have got Abela at page 590. The point I'm simply making is that 615 only applies to cases where you've tried to serve overseas, where the defendant is overseas, because of a particular provision in 637. And therefore, the fact that, perhaps you weren't suggesting this, the fact that alternative service is available for service overseas is not evidence that that is true about the rest of the regime in 6.3 and following.
Well, 6.37 provides the identification of which grounds are relied on for service out and how that is to be effected. And 637.1a(c) brings in the defendant's address, or if not known, in what place the defendant is.
No, I was looking specifically at 637.5. Where the court gives permission to serve a claim form out of the jurisdiction, it may, one, give directions about the method of service and give permission for other documents to be served out of the jurisdiction. And somewhat artificially, you might think, but looking for a route, Lord Clerk said that's the route by which 615 comes to apply in cases of service overseas. Fine, I'm only making the point that he had to find a route, even a rather odd route, because otherwise 615 wouldn't have applied, because it's not part of the provisions relating to service overseas.
Yes, I'm struggling slightly to see where that takes one at the end of the day.
Well, it
because
takes one,
6.40 is
service
not
direct doesn't simply take you to all the English rules, as Richard, all the rules about service within the jurisdiction, as Mr Justice Richard Jacobs believed in whatever that case is called, FNP.
KBN Bank, FBN Bank. Yes. Well, but that is premised upon your Lordship's suggestion that 640 is a complete code.
Well, that's what I was wondering. I may be wrong about that, but I
purport to be and isn't.
Well, if you,
I mean,
there's authority that it isn't. That's fine.
Well, it is because your Lordship has already referred to Lord Clerk's reference to the application of 6.15 coming in through 6.37.
But that was my precise train of thought. It was only because it must be on the unspoken assumption that 640 is otherwise a complete code, that it was necessary to find something to import 615 into the case where the defendant is not within the jurisdiction. And that was found in 637.5.
Well, you have to find somewhere in the rules a method for service out, and we do, because 640 refers to 642, which refers to service direct.
Yes, and The question is, does Service Direct simply throw you back to 643C, which is what I was suggesting?
But it
Or
doesn't.
does it throw you back to the provisions of, it is very annoying not having the complete rules here, but,
So sorry, my lord, 6.3 to 9.
well, actually, we do, we're
637(5) is cited in Avela, page 590 of the bundle.
and actually I'm wrong anyway, because, if you look at the 637 falls within part 4 of the, well, section 4, I think, of part 6, service of the claim from another document out of the jurisdiction.
Yeah.
So,
I mean,
I'm not wrong, but the point I'm wrong to say that 637 falls outside the scheme for service out of the jurisdiction. It clearly is part, now we've seen the title page, it is part of this section of the rules, so in a sense it's a fortiori. That wasn't a problem about 615 because you could import it via 637, but you couldn't 637(5). But whether you could import any of the other provisions of section 2 of part 6 seems to be much more doubtful.
There's no logical distinction between the incorporation of 615 and any of the other permitted methods of service under English law in 6.37(5). So that in itself would not, I respectfully suggest, indicate that 6.40 is in any sense a code. I mean, the reality is that there is a whole section, a whole part of the rules dealing with service out of the jurisdiction. There are a whole series of different ways by which one can reach that, and for that matter, under 6.37(5), as your lordship points out, there is power in the court to give directions about the method of service. And that again, there's no difficulty with reading that together with 6.42(3) in identifying that in the circumstances which arise there in relation to the limited range of countries, the court can give directions as to how service should be effected and did do so.
Well, maybe you're right. I was exploring all this on the hoof. It requires a bit of further thought.
It's just that I think there's a danger in getting rather too bogged down in the minutiae here. There's a very broad structure. The English, what I ask for your comment on, it's a broad structure. The English court gives permission to serve out of the jurisdiction. And as far as the English court's concerned, prima facie, it would expect service to be in the form that service of English proceedings would be, as set out in the rules. There are exceptions to that. You can't do it if it's unlawful to do that in the foreign country.
Yes.
You will not sanction somebody doing something which positively unlawful. And it cannot be done if there are treaties or conventions which prescribe the way that service in that country is to be done. But other than that, you have freedom to serve as you may serve. The further thing then is there is an addition. You may also serve in a manner permitted in that country, even if it's not permitted method in English proceedings. And the one further restriction that seems to me is the one which we haven't yet come to, which seems to be the crucial one, is Practice Direction 6B, which provides that in certain Commonwealth countries, you have to do it through the judicial authorities.
Well, that's the ground too, and it raises the question, there's a preliminary question as to whether His Lordship actually decided
Yeah.
that point.
I think one has to
But
bear
yes.
in mind here that this is not meant to be a restrictive regime, which it's meant to say you have been granted permission to serve. So you have to look at these rules not in trying to find some sort of maze you have to navigate through. The basic rule is you can serve this person. The court's given permission.
Yes,
But
respectfully
there are
agree with that.
There are certain respects in which you can't do it, which is if there are treaties or conventions, and if those don't apply, then direct service applies.
But whereas here there is no applicable convention or treaty, you've got, haven't you, really two, with 640 and 642 read together, you've got two possibilities. One is by any other method permitted by the law of Mozambique, that's 643C.
Yes.
Or you go to 642, and because you're not dealing with a convention, you're in 3, and specifically 3A, 642 3A. You can you actually, it says must affect service direct unless practice direction 6B provides otherwise. So at that stage, before you get to practice direction 6B, which I hope we're going to look at fairly soon, because as my lord says, seems to me it's pretty critical. You've got those two possibilities, whatever service direct means. But what that's making clear is that if practice direction 6B does provide otherwise, then you can't do it by direct service, whatever direct service or service direct, whatever that means.
Yes, and I mean, ultimately, that is the point that we applied. We got permission under 6.37 for the forms of service that we've identified, and we say that they are permitted because they operate through 6.40, 6.42 anyway. But ultimately, as my Lord Justice Phillips says, this is various methods of service which the court countenances unless there's some prohibition on it.
Yeah.
And there isn't a prohibition on it. That's the
Well, so you say.
6.44 is not satisfied.
That depends on your being right about practice direction 6B.
That depends upon 2 in effect. I mean, first of all, practice direction 6B, paragraph 5.1, and it also would be excluded, as my Lord Phillips says, Lord Justice Phillips says, if the Mozambican law expressly provided contrary to it.
Yeah.
So that would be the 2 mechanisms. So the English court doesn't, as it were, infringe the sovereignty of other states by imposing methods of service that those states have determined are unlawful under their system. That's the sort of recognition of comity. But beyond that, any method is permitted, provided the rules themselves haven't outlawed it, and that's intended to be the achievement. And we say it is achieved on any view by the ability to serve direct if you haven't been brought into one of the conventions and treaties. And the respondent, in its reason 3, says, well, we are somehow transposing by 6.43C or 6.44 the English methods of service. We are not seeking to do that at all. We don't rely upon those for those purposes at all. We say they come in on any view by 6.42.3, the FBN bank case, and all that 6.43C does is to add other methods of service permitted by the foreign jurisdiction. If you look at the FBN case, there's the whole section of the judgment where His Lordship looks at methods permitted under Ghanaian law, and that may permit methods that English law would not contemplate. But that is...
The real difficulty for you, at least on my part, is practice direction 6B.
Yeah.
And for my part, I really want to hear what you've got to say about that.
I'm certainly happy to go to that. May I just clarify whether there's anything, there's a point taken about the nature of documents and so on, but I hope your lordships are aware that the certificate of service in the supplementary bundle at tab 23, pages 348 to 349, identifies fully what was served. And it's suggested that somehow service on the security checkpoint at the presidential palace is not service at the palace, which again we struggle to understand how that could operate. We certainly would contend that it is, and that there isn't any basis for suggesting otherwise. I can certainly deal now with the second ground of appeal, which my Lord Justice Phillips is directing me towards. I would be unhappy
I
to.
wasn't directing you, I was suggesting that would be the point that would really interest
Yeah,
me.
the really interesting point is 5.1, practice direction 6b, paragraph 5.1.
I shan't adopt the former Lord Advocate's approach of your Lordship's inviting me to depart from my chosen order of presentation, and I decline that invitation. I'm going to
Your
exceed.
Lordship inviting me to depart from my skeleton argument.
I'm happy to turn to that.
No, you take your own course.
All I wanted
There's
to-
no element of teasing you here, I'm afraid.
Not at all. I just do feel that I ought to cover off the other points, but I'll come
Well,
back to them.
we've got your point about, I understand the point that if you're right about service direct, you say, well, leaving it with the police at the checkpoint outside the presidential palace suffices. Perhaps suffices is an inadequate word, but that's good enough.
And
Because unless it has to be personal service, as in putting it in his hand, then it's
yes,
one's dealing with it in a way which we perfectly understood under our rules.
yes. And now the position, the
Sorry to be slow. If we are on that point, just point me to the rules which, if service direct means what you say it means, how would leaving it at the checkpoint be effective service under part 2 of, section 2 of part 6?
because at that point, if your Lordship goes to 6.9,
Yeah.
This rule applies where those various methods do not apply, subject to subparagraphs 3 to 6. The claim form must be served on the defendant at the place shown in the following table. Nature of defendant to be served: 1, individual, place of service, usual or last known residence.
I see, so it's simply on the basis that the palace is his residence.
Indeed.
Yes, I see, sorry, I was being slow. Thank you.
No, I want to make that clear. So on any view, that satisfies that requirement within 6.9 and therefore comes in. And it's not at all clear from the judgment that the judgment dealt with paragraph 5.1 as a bar to service on the basis that there was a list. Indeed, he seems to have formed the view, in our submission correctly, that there was no list, and therefore 6.b 5.1, practice direction 6b, paragraph 5.1 doesn't operate as a bar because there was no list. But what he seems to have done is conflated that issue with the issue of whether this method of service was permitted by or contrary to Mozambican law, which tests he again conflated. And he seems to have used the information obtained by the Foreign Service
On process section.
process section, indeed, as indicating that somehow, because that was a method of service which they have identified as a permitted method of service in relation to Mozambique, therefore it is a method of service that was not permitted under Mozambican law, and then he's conflated that as being contrary to Mozambican law. So he seems to have addressed it in that aspect of the case, where in our submission he's simply wrong to have done so, because nothing that the Foreign Process Service Office will tell you, Foreign Process Section will tell you, is as to whether something is contrary to Mozambican law.
No.
and they don't purport to, they simply identify what is a method.
They would only identify what the usual method for service is in the foreign country.
And what they did not have and do not have is the relevant list that under 6B, Practice Direction 6B 5.1 they should have for the purposes of being able to operate that bar, if that bar is to be relied upon. So our starting point is the judge didn't find against us on this, and indeed Lady Justice Lang seemed to be of the same opinion in giving permission to appeal. And therefore, strictly, that is not something that we need to cover off, but we do in our ground 2 for completeness, and we have the Practice Direction Service out of the jurisdiction 6B beginning at page 326, which you have in your hand up the relevant paragraph 5.1 at page 21 of the bundle handed up. And that deals with service in a Commonwealth state, obviously applicable to Mozambique. The judicial authorities of certain Commonwealth states which are not a party to the Hague Convention require service to be in accordance with Rule 6.421b1 and not 6.423. A list of such countries can be obtained from the Foreign Process section. And we say that that second sentence defines the first sentence, as it were. There is no list, and in those circumstances, we cannot be precluded by Practice Direction 5.1 from operating the rules.
Well, that's the submission. I find that, I must say, difficult to swallow, speaking for myself. But what's the difference between being told by the Foreign Process section this country is one such country within the first sentence of 5.1 and the existence of a physical list? I mean, the physical list would just be a list, literally. You know, I don't know how many there are. Let's say 25 countries on a piece of paper. This, in one sense, what you got here was no doubt because there isn't a physical list. What you got was more detailed information from the Foreign Process section.
Well, what we received from the Foreign Process, or was received from the Foreign Process section, did not purport to be a limit or indicating that that was the required method of service.
So
If we go in the core bundle,
the minutes, did you say?
I'm so sorry, my lord.
Did not purport to be what a limit?
To indicate a requirement or that a document, that the country was on a list that required that. The information that we have in relation to that is in the core bundle tab 7.
Hang on.
And the, sorry, forgive me a moment. Yeah, and what the Foreign Process section purported to do was to identify a method by which, I mean, they say the only service method available in Mozambique is agent to agent. But in our submission, first of all, that doesn't demonstrate that for the purposes of the Practice Direction 5, that this is intended to be a country on the list of countries which requires service to be in accordance with those rules. And secondly, as I indicated, it clearly doesn't operate by way of a list in relation to those countries. It has simply identified a method of service which the jurisdiction Mozambique is willing to accept.
No, it says in terms, by necessary implication, that there isn't service available through the judicial authorities.
I mean, the way this is all, as I understand it, what has happened, and yet again, we haven't actually got all the documents, but it looks as if Mr. Dixon's instructing solicitors wrote to the Foreign Process section on the 31st of July last year. The email begins at the bottom of page 68
Yes.
of the bundle, and they quote they set out a summary of the approach that they understood the Foreign Process section took to serving proceedings in Mozambique. And they've obviously obtained at an earlier stage copies of the letter of request and the template. And they effectively ask the Foreign Process section to confirm that that's the position, which they then do by the email later on the 31st of July, which is the one at the top of page 68. And that provides in terms that the only service method available is agent to agent, which in this context means through the relevant judicial authorities.
Well,
And requires a letter of request, a covering letter, and the N244 form.
well, the difficulty is ultimately a question of interpretation of this. And we say that they are being asked about methods for service, and obviously the Foreign Process section is being asked how the process proceeds, and it, from its perspective, simply says in the fourth paragraph, under the method agent to agent, the Foreign Process section does not get involved. And instead you would need to obtain either a solicitor or process server in Mozambique for them to carry out the service. So what they're effectively saying is we do not get involved in the process. It is not dealt with through the Foreign Process section. And therefore we would say if you're trying to find a list identifying the countries which require service to be in accordance with those other two rules, we would say this does not satisfy the requirements of that list. It doesn't identify that that country is such a country.
Can I just understand that as far as the first sentence is concerned, that's the substance of the provision. It's that certain countries require service to be in accordance with, effectively, through the judicial authorities. And that's the requirement that's being addressed. Do you accept that Mozambique is such a Commonwealth state?
We don't say that there is the evidence before the court on which you can come to that conclusion. That it is such a state that requires that process.
Why not?
Well,
If this correspondence is taken at face value, why not?
because what this correspondence is doing is demonstrating, how, first of all, that the Foreign Process section does not get involved, which in and of itself would suggest that that doesn't answer the question of whether you have to serve through the procedures identified.
Well, that's not true. It says it doesn't get involved, but if you read the rest of it, what actually happened, I mean, it's not the first time one's come across this issue. What actually happens is your solicitors would submit the claim form together with the usual pack and the acknowledgement of service and everything else. Complete the attached letter of request, then submit those documents, including the letter of request, to the foreign process section, who say in subparagraph 3 that they'll arrange for the senior master to sign the letter of request. And you also need to include a covering letter addressed to them and the N224 form. Then the foreign process section they get involved to this extent. They make sure all those documents have all the necessary signatures and stamps and all the rest of it. They then send them back to you, and you then send them to your chosen solicitor or process server in Mozambique. So that's how this works. But what they are saying, at least as I read it, is that that's the only way in which you can serve in Mozambique.
Yeah. To spell out the obvious, the letter of request we have it at 72 is to the competent judicial authority.
Precisely.
But as Mr Justice Knowles in argument pointed out, that simply is the form of the letter of request that you would use if you went this route. That still begs the question of whether that which is held by the foreign process section is a list for the purposes of 5.1 sufficient to oust the operation of the first part of the 6.43C. 6.42.3, sorry. I mean, ultimately it is internally inconsistent in the sense that it says the foreign process section does not get involved, but then as your lordship points out, it might arguably then be said to indicate a way in which it does get involved.
Well, I think it's simply making the point they don't get involved in the actual service, and that's all they're saying. They prepare all the documents and they send them back to you, and it's then up to you to forward those documents. I mean, in other circumstances, the foreign process section do get involved in the service of documents out of the jurisdiction.
Well,
you just don't in this one.
There's a limit how far I can take this, my lord. The point is, we're entitled to serve in accordance with 6.42.3 as we have, unless 5.1 precludes us doing so.
Yeah.
And in order for 5.1 to preclude us doing so, it would have to be identified that Mozambique was on a list of countries which was not a party to the Hague Convention, but which required service to be in accordance with those other two rules. And we simply say that there isn't the evidence or information before the court on which you could form that conclusion. Mr Justice Knowles, we say, didn't actually form that conclusion because he didn't actually determine that point on that ground.
Again, you conflate the question with respect by saying, is there a list of such countries? There seems to be two questions. The first is Mozambique a Commonwealth state where the judicial authorities require service to be in accordance with 642(1)(b)(1)? That's the first question. And then the second question is, if there is no such list, is the existence of a list a precondition of the courts of this country giving effect to the stipulation of the Commonwealth state?
I mean, our primary position is yes, because if the party here is entitled to serve by the method identified, unless it is ruled out by something specific and clear in the rules, and the rules have identified what it is that will rule it out, namely one of those relevant countries identified on a list. And there is no such list, and there is no identification for the court as to whether the court, the Mozambican authorities are or are not within that jurisdiction. In the absence of a list held by the PS which we haven't seen and which there isn't, there is no evidence before the court that the first sentence of 5.1 is satisfied.
Has somebody asked for the list?
That is what was initially done.
Where do we see that?
Well, give me a moment. It's cited in Mr Justice Knowles' judgment at paragraph 9, where he refers to the inquiries by the parties of the foreign process section have not identified a physical list.
Well, that doesn't mean that anyone asked for a list as such. It could simply be a reference to the correspondence which we've got. For its effect of its summary of its effect.
There was some information given to the judge from the bar, I believe, by my predecessor, as to inquiries that had been made and to the effect that there was no list. And the argument that proceeded before Mr Justice Knowles was on the basis that there was no list.
A member of the bar wouldn't know, but he would have been told by his solicitors.
He was given instructions by those behind him then and now, yes.
But no evidence was put in about that.
I'm so sorry, my lord.
No evidence was put in.
There was no evidence, my lord.
It seems strange that an administrative error, perhaps, on the part of the FPS would deprive Commonwealth states, which are so stipulated, of the right to so stipulate, and particularly where the FPS is quite happy to tell you in relation to any particular country whether they have so stipulated. It seems it would rather be putting form over substance and removing the effect of a perfectly sensible rule.
Well, there are two aspects to it. The first aspect is whether the rule needs to be complied with. So the rule needs to be complied with in order to oust what would otherwise be a permissible method of service. The second aspect is, if you're ignoring the structure of the practice direction rather than rule, if you're ignoring the structure of the practice direction and saying, in fact, you only need to satisfy the first sentence and you ignore the second sentence, then it should be a question of evidence of Mozambican law as to whether that is or isn't what they require. And there is no evidence of Mozambican law as to what they do or they don't require.
Just from my note, I suspect it's not really decisive. What is it that Mr Swaroop told Mr Knowles exactly about the inquiries that have been made?
May I dig that out?
As you can tell us later, we're grateful, my lord. And just while we're on the one further point, whether or not there is a physical list as to which we don't know what the judge was told, in the sense, physical in the sense of on a piece of paper, you would think that the computer at the FPS would have to have a list of some sort so that they could interrogate it as to what's the position in this or that country and come up with the answers that they did.
There are multiple theoretical possibilities. What we say is that unless and until this court has some, or indeed the first should have been available to Mr Justice Knowles, has proper evidence as to either compliance with the full scope of 5.1 or at the very least some proper evidence in relation to the first sentence of 5.1, it's not appropriate for the court to proceed on the basis or the assumption that the first sentence of 5.1 is triggered. And what one's back to is the other provisions on the rules, namely, this might not be a method permitted by Mozambique. It might or might not be, but it is not a method contrary to Mozambican law unless and until there's evidence to establish that fact, and there's no evidence of that before your lordships.
It seems to me that if you were to ask the foreign process section for a list of the countries covered in 5.1, they'd be obliged to give that to you A, because it's referred to in this provision, but also under the Freedom of Information Act. So insofar as it says a list of countries can be obtained, I would be sure it can be. It doesn't say with any particular time period. I mean, if you ask them, I'm sure they would have to give it to you.
Well, that is a very complex question.
It's a very unsatisfactory position that we find ourselves in this court. I mean, either the list that's referred to is a chimera, it doesn't exist. There is no physical list, which I suspect is the reality. Or if there is a list, nobody's bothered to ask for it.
No, that has been addressed, as I understand. It's common ground that there is no list.
It doesn't say there's a list. It says a list can be obtained.
Well,
and if you want to read it strictly, let's read it strictly.
Well, you could say, as my lord says, what you could say is, well, if you'd asked the foreign process section, anybody asked the foreign process section, well, which are the countries to which the first sentence applies? They might have given you the physical list that's referred to, because there may in fact only be, we know of two, Mozambique and Ghana. There may only actually be about 10 for all we know, perhaps not even that.
but that's not a gap in my evidence.
No, I'm not suggesting
That is a gap in the respondent's
of your
evidence.
client. I'm simply making the point. Here we are in the Court of Appeal, asked to decide what's effectively a point of principle, with quite a lot of hand-wringing going on as to what is or is not. And I know how difficult it is to get anything out of the foreign process section, but one might have thought that this is a pretty simple sort of question, really. Anyway, we've got what we've got. And you say it's not, what we've got is not enough to satisfy the first sentence of paragraph 5.1.
Yes, if we even get to this territory, our starting point is that it's not a point that was determined against us by the judge anyway, and it's.
Isn't it taken by way of respondent's notice?
Same by the respondent's notice.
It is identified, but then it would need to be properly proved and established by evidence supported by the respondent.
Well, that's a different point. But you were saying we don't even get to this point because it wasn't how the judge decided it. That's a non-point, because the respondents are saying if that's true, it's how he should have decided it. So we put in the respondent's notice. So I don't think you get anywhere on that.
Yes, I think I've said all that can be said about it. There's no list. A list was requested, and we were told that there is no list in the run-up to the hearing before Mr Justice Knowles, because the point was raised.
Well, you're going to give us chapter and verse about that.
That's coming through. The point was raised by at a very late stage, as your Lordship will have seen from the date of the evidence relative to the date of the hearing before Mr Justice Knowles. It was the day before, 2 days before the hearing, I think it was, that this information came through from the respondent in relation to their exchanges with the foreign process section. And so it was dealt with in something of a hurry, and nobody has sought to put any additional evidence before the Court of Appeal in order to take that farther.
I mean, it's interesting that, you say the judge didn't deal with it in his judgment, and you may very well be right, but he said he did deal with it in the refusal of permission to appeal, where he actually said this: on service, I consider there's no real prospect at all. CPR 642-3A engages PD 6B, and that was not complied with. Service through judicial authorities was required, agents assist in this, and was not achieved until 2023. Authorities cited do not assist. There was no evidence even that the method that was used in 2021 was the method permitted by the law of Mozambique. I mean, that's a different point, but the first bit of that is pretty categorical, isn't it? So
but it's not in the judgment.
He appears to thought that he was deciding the point,
My lord, may I just tell your lordship, that Mr Swaroop informed Mr Justice Knowles that those instructing him did actually call the FPS and asked about this issue and were told there is not such a list and that they can put that in a witness statement if your lordship requires. And Mr Justice Knowles says, and Mozambique is not on it. Mr Swaroop, no, there is no list. Mr Justice Knowles, there is no list, sorry. Mr Swaroop, the FPS does not have such a list, and Mr Snelling can put that in a witness statement. Mr Justice Knowles says, I think I'm prepared to accept that from, you're conveying that to me from someone who's an officer of the court, I can accept that. There may be a question about the reliability of the answer that Mr Snelling was given. I don't doubt he was given the answer. So that was the exchange at the time about the
There's an obvious ambiguity in that. We weren't on the call. There may not be a list in the sense that in his desk, as would have been the case 30 years ago, there is a piece of paper with 16 names on it and some crossed off from time to time and some added from time to time. But it's held on the computer. It must be held on the computer because otherwise how could they answer the questions they did answer? We just don't know what Mr Snelling asked in sufficient accuracy.
Again, the deficiency, if it is to be said against me that 5.1 rules out my otherwise acceptable method of service, the burden on that must come from the respondent.
Well, it all depends on the existence of a list being a precondition for the operation of the rule in the first sentence of 6b.
It doesn't entirely, because the other aspect of that is if we get to the second bit of merely the respondent needing to satisfy the first paragraph, first sentence of that paragraph, then again we say there isn't the evidence before the court.
Well, that depends whether we accept that the correspondence with the foreign process section was sufficient.
Yes.
So the question isn't, is there a list? The question should be, can you provide me with a list?
I understand all of these points, and they might well have been good points for the respondent to have raised with the FPS and to raise with the court and to give evidence in relation to the court as to whether the FPS can give such a list or would give such a list. But there isn't that evidence of any of that before the court. So the court cannot be satisfied. Mr Justice Knowles proceeded on the basis that there certainly was no list, didn't factually address what I appreciate your lordship is raising as a separate point, which is whether a list could have been created for the purposes of answering any inquiry. Whether that's something that they would have been obliged to provide by way, I'm certainly not getting into, unfortunately, because my knowledge on the hoof of what the FPS would be obliged to create by way of a list for the purposes of satisfying Freedom of Information Act answers, I think is not the best place for me to try and address that. It's not without its complexity. The short point is I have to proceed on the basis of the evidence that's before the court and what has been put before the court by the respondent in order to satisfy the court that there is in fact a bar under 5.1. And that is all.
What's said against you in the respondent's notice, I think, can't recall now without looking it up whether it's the same thing said in the skeleton. What they say is the position was confirmed, paragraph 6 of the respondent's notice. Position was confirmed by the FPS, see the judgment paragraph 9, PTA refusal reasons on the basis of all the materials provided by the FPS. Paragraph 6b, paragraph 5.1 of Practice Directive 6b applies because the FPS confirmed Mozambique is recorded on its system, i.e. effectively listed by the FPS as requiring the involvement of Mozambique's judicial authorities, etc., etc. And I think that's an interpretation of what the FPS said, but it's probably an accurate interpretation in the sense that, I mean, on the assumption that the FPS operates some sort of computerized system as opposed to using quill pens, which may be quite an assumption, of course, but make that assumption for the present. That seems to me to be what that correspondence with the FPS demonstrates.
Well, what it demonstrates is that, first of all, we haven't got the list. Secondly, the FPS have indicated that that is the method of service that they experience in relation to Mozambique. And what we say is that there isn't the evidence that Mozambique in fact precludes. If one were to ask this way, what is the provision of Mozambican law which gets it within, as it were, the first sentence of paragraph 5.1? And the answer is nobody in this room has a clue.
But even if there was a list, we wouldn't know that. All we would know was that Mozambique requires service through judicial authorities.
I could understand that if a list is provided satisfying 5.1, it could be said against me that the list defines, for the purposes of 5.1, who is within it. And in that circumstance, I might struggle to argue against the existence of a list and Mozambique's name on it and seek somehow to go behind that. But there is no such list. Therefore, one does have to go behind it. One does have to answer the question, what is it that makes Mozambique satisfy the first sentence of 5.1?
The same, but you just get the same point. If, which is a separate point, the correspondence with the FPS amounts to a statement by necessary implication that Mozambique requires service through judicial authorities, there's no need for you to have to say, well, show me the provision of Mozambican law that does so. That by itself, as a statement by the FPS, would be prima facie evidence.
But that's if we've got to separate out the two different routes. One route is that the list is definitive. There is no list.
Yeah,
therefore
I've got
it can't
that.
operate. The second one is that the first sentence is definitive and has to be
No, it's
demonstrated.
not definitive. It's, the first sentence says what the that some Commonwealth states require service to be in accordance with 642
Service through
1B1, i.e.
judicial
judicial
authorities.
authorities.
And one would have
And then you say, well, is there evidence that that is the case? Yes, there is. See the correspondence with the FPS. You say, oh, well, that's not good enough because it doesn't tell you what provision of Mozambican law has that effect. But the statement in the correspondence ought to be enough, oughtn't it?
no, because if one is contesting this as a matter of law, as to whether this is or is not, as a matter of Mozambican law brings it within that, then it's a matter of foreign law. There should be expert evidence in relation to it. No application was made for permission to adduce any expert evidence, and the matter could then be contested. There is nothing in the rules which says that a statement or determination by the FPS is definitive in relation to this. That is then, it becomes, if there isn't a list, and you can't go that route, but you're still entitled to apply 5.1, and you're still entitled to go to an analysis of the first sentence, then it's a question of expert law. And in those circumstances, the party seeking to rely upon it would have to apply for and adduce expert evidence in relation to it. And they might say, well, the evidence I propose to adduce is from the FPS.
But this is if there'd been a list, if there was a physical list of the countries to which the first sentence of 5.1 applies, then that would be definitive, wouldn't it? It'd be the beginning and the end of it. The FPS would have produced the list, which it would have said the list of countries, Commonwealth states, which aren't parties to the Hague Convention, which require service in accordance with, or service to be through judicial authorities. And here they are, these 10 countries. You wouldn't need expert evidence of Mozambique law.
I can see a construction of paragraph 5.1 which acknowledges that if there is a list and if Mozambique is on that list, you may not be able to challenge that. That isn't the situation. The question, therefore, is, can you somehow otherwise satisfy the first sentence of 5.1? We say, if you are going to be allowed to do that, then it becomes a question of expert evidence of foreign law, and it is up to the person seeking to rely upon it to make an appropriate application to the court, to seek to adduce that evidence in relation to it, gives the other party an opportunity to adduce contrary evidence, and the matter can be resolved as a matter of expert evidence. But that's not what happened. all that's happened in this case is that a communication to the FPS was made orally, followed by an exchange of emails by the respondent, put before the judge, as it were, momentarily before the hearing. And that, we say, does not satisfy the requirements for adducing the appropriate evidence in relation to the position if you are going to go behind the requirements of 5.1 and say, well, actually, as a matter of Mozambican law, is Mozambique such a country? Because if absence of a list, that's the only way you can satisfy the first sentence.
Might have thought there would have been correspondence back in 2021, but there we are, we haven't got any if there was.
I think I've not only taken it as far as I can, but I've taken much more of my time than
You probably drained that
permits. Yes, there are a few points that I would like to touch on and pick up just to sort of dispose of that are sort of raised by the respondent's notice in one way or another.
Yeah.
But I don't want to waste my or the court's time with it if they're not of interest to the court, but I will pick them up as I go along.
Well, if we'll tell you if we don't think
I'm
it's
grateful.
helpful.
I'm grateful. I think I've fully dealt with the difference, and I don't need to take further, between contrary to law and permitted by law,
Yeah.
and the Supreme Court case and the first instance decisions, which have all adopted the same approach to that, which is that contrary to law does not mean the same as not permitted by law. It requires something more than that, there has been some additional material put in from a law firm by the respondent, which they raise at their reason 8, and that is in the supplemental bundle at tab 13. We've dealt with that in our skeleton at 34. Essentially, there was never any permission for that to be added and adduced. The learned judge didn't rely upon it or refer to it. It would never have been permitted to be adduced because of the lack of independence of that law firm relative to the Republic. And so the long and short of it is that that material is not appropriate material for this court to have regard to either. And if your lordships were nevertheless minded to look at it, you would see that it is very long on assertion and very short on authority. And it doesn't take home the point, and indeed the point it was asked to consider was the permission point, not the contrary to law point.
Yeah.
That I've dealt with. I just want to nail the fact that Rule 6.40, subparagraph 4 in relation to contrary law is not only a provision relating to alternative service. The fact that we cite cases that deal with alternative service that construe 6.40 sub-rule 4 is neither here nor there. That simply happens to be in the context in which that provision fell to be construed. It matters not a jot that is the case.
I don't require much further assistance on that point.
Principle is the same. There is, in reason 2 of the respondent's notice, a point based on section 12.1 of the Statutory Immunity Act, which is a suggestion that my client should have followed the procedure.
Sorry?
I'm sorry, it's reason 2.
Yeah.
And that is the suggestion that the procedure for service on a state in section 12.1 should have been followed. And the short point on that is it's wrong. It was rightly not adopted by the learned judge. Section 12.1 only applies to a head of state acting in his public capacity. The route to that is that section 12.1 only refers to states, and a head of state is only a state for the purposes of the Statutory Immunity Act if he is acting in his public capacity. And that is section 14.1a of the Statutory Sovereign Immunity Act. And so 12.1 would only avail the respondent if it could show that the proceedings were brought against the President in his public capacity as head of state. And those proceedings are not so brought. The judge was supremely well placed to assess the issues in the light of his extensive exposure to the case and its issues, more than monthly CMCs, extensive disclosure issues, identification of issues, etc., and the learned judge concluded that paragraph 3, that the proceedings were not being brought against the President in his public capacity as head of state. It is striking that to challenge that, the respondent focuses in its skeleton at paragraphs 9 and 33 on a reference in the Privinvest's pleading to the effect that these proceedings were brought consequent on a volte-face by the President, who, on becoming President, repudiated the very transactions which, as Minister of Defence, he had been instrumental in concluding. Not immediately, there was a time lag. But it's not the repudiation of the transactions which underlie the claim. It's his involvement in entering into them and inducing Privinvest to make the payments which it did or promised, which underlie Privinvest's claims. The campaign contribution representations were made in 2014, for example, before he even became President. And the Republic's case was that promises were made prior to the contracts being entered into and payments made after. So that we say is sufficient to dispose of that. And it also accords, importantly, with the position adopted by the Republic. One has to bear in mind, this is the state's immunity, which is extended to the President, can be waived by the state. The state's position is that we were not permitted to go the section 12.1 route. And that is in the supplementary bundle, tab 22, in the letter from Peters and Peters on behalf of the Republic. The letter begins at page 340, but the relevant bit is in 346 to 7, at paragraph 23H. In tab 22, the letter of the 3rd of March 2021, and just to give it its context, the proceedings to serve out were served on the other parties, including the Republic, and they received a response in the form of this letter from Peters and Peters on behalf of the Republic, criticising the documents which were to be used in the application for permission to serve out.
I'm sorry, I haven't got the front page of that letter, but I suppose I don't need it, do I?
I'm so sorry, my lord, and it's not at the back of the previous tab or anything so helpful as that.
No, I've just checked that.
No, I'm so sorry.
It doesn't matter unless I need the first page.
It's not important. It simply is that page simply gives you the date, the sender, and the
Which paragraph of the letter were you looking at?
So it's the very last page, the paragraph beginning on the penultimate page, deficiencies in Snelling form in relation to the fourth party, criticising Mr. Snelling's fourth witness statement, and says at H, it wrongly states at paragraph 199 that the fourth party is capable of being properly served via service on a state pursuant to CPR 6.44. That's the 12.1 and 6.44 point. So the Republic said you can't go that route, endorsing that it was not against him in a public capacity, and we didn't. And therefore we say it doesn't lie in the hand of the emanation of the state, namely the President, to take a different position from that which is taken by the true owner of the immunity, namely the Republic. There is something made by the respondent in reason 9 of its respondent's notice as to the issue of whether the documents were received or not. We say that that is irrelevant technically, because the short point in relation to it is that if he is properly served, it doesn't matter whether he has in fact received the documents or not. And if he's not been properly served, we're not suggesting that by some alternative route or that he should have been deemed to have been served. We've made no such application at this stage. So it really doesn't matter However, there is considerable assertion in relation to this on the part of the President, but there is no evidence. And when your Lordships look very carefully at what is actually said, in any way, even by his solicitors, it is that he didn't receive service of the documents. And so you will look in vain for finding actual evidence of the suggestion that he hasn't received the documents. But ultimately, I mean, it would be a very odd thing if he hadn't, because he's President of the Republic, which has pursued this case for the last 3 months on the basis that it is a fundamentally vital case for the well-being of the Republic, of which he is President. And the idea that he was unaware of all of these documents and matters, and as you can see, all of the material documents had been provided to the Republic such that they were able to critique them in advance of the application before Mrs. Justice Cockerell, makes it a bit strange that the suggestion asserted that he hasn't actually received the documents. But as I say, there's an important distinction between whether he acknowledges that he received the served documents, or whether he actually received the documents. But ultimately, we say it doesn't matter. It is suggested in in the reasons, respondents' notice reason 4 in paragraph 15, that if our construction were right, then the whole area of alternative service would be OTOs. And we just don't begin to understand how that can possibly be right. Obviously, alternative service deals with all sorts of ways in which the court might order service to take effect. For example, some of the other routes that we were applying for, such as service by certain email addresses.
Yeah, I was say service by an email address is the obvious
It's a classic example, and that doesn't in any way render. It's not at all suggested that Section 644 would render the requirement for an application of OTOs. That takes us to sovereign immunity, ground 3. And as I've indicated, this arises if and only if Privinvest fail on the points hitherto. We've dealt with this in paragraphs 41 to 59 of our skeleton argument. Essentially, Privinvest were trying in parallel to serve President Nyusi through official channels. We were unable to do so for the reasons that I've indicated, the business of the President's diary, until 2023. Ultimately, this boils down to the competition between views expressed by Mr. Justice Voss, as he then was, and the views of Lord Justice Briggs, as he then was in Apex Global Management. They were expressed in both fora obiter, but it is recognised that they were fully argued at first instance before Mr. Justice Voss and not fully argued in the Court of Appeal before Lord Justice Briggs. It is in truth quite difficult to take matters much further than the judgments themselves, which your Lordships have seen and which the Mr. Justice Knowles cited from in detail in his judgment. The test is one of necessity, and if I can just, I don't want to waste the court's time on this. Obviously, it arises out of Section 20, subparagraph 1 of the State Immunity Act. That incorporates, for the protection of the head of state, the same protection as is available to diplomatic missions, which was encompassed in the Diplomatic Protection Act, and the question is how exactly one applies across the provisions of the DPA to the position of the head of state. The most fundamental point, of course, is that in the context of a diplomat, his protection is related to his time in a receiving state. That doesn't have any obvious application in the context of a head of state. And similarly, it applies in relation to his commercial and professional activities in the receiving state. And so the question is whether you apply the provisions of the DPA with or without modification, and if with modification, what modification is necessary in order to make the relevant provision of the DPA applicable to a head of state. And in short, for the reasons identified by Mr Justice Voss, as he then was, he came to the conclusion that it was necessary to revise the provisions of the Diplomatic Privileges Act, to modify them in order to remove the territorial limitation on where the commercial and professional activities were carried out, so as to extend the exception without territorial limit. And in that sense, matching the modification which was necessary to extend the application of the Diplomatic Privileges Act without reference to the president being within the receiving state. So it's a mirrored immunity. And everybody who has commented on it accepts that it is not a model of clarity. Everybody accepts that the circumstances in which it came into existence is not a model of clarity. It is acknowledged that in the Pinochet case that one shouldn't have regard to the parliamentary process through which it was amended and revised, but then it's also said even if one did have regard to that, one wouldn't be very much the wiser. And so ultimately the statutory provisions we've set out for speed and efficiency in our skeleton argument at paragraphs 41 and following. The matter has only been debated in the Apex case, that we could see the matter has been touched upon in obviously Pinochet at some length, but in the criminal law context, clearly, because that is what they were concerned with there. And there's also a decision of Mr Justice Laddie, which deals with this, but the point was not argued. And he seems to have approached it on the basis that there was an absolute immunity in relation to the president, in relation to commercial and or criminal and civil suits, full stop, which is, we say, difficult to reconcile with the wording of Section 20, which incorporates the Diplomatic Privileges Act limitations, amongst which are an exclusion for commercial and professional activities outside, obviously, the official capacity of the diplomat. The burden is obviously on the respondent to establish his immunity from suit to the extent necessary. Therefore, I shall come back to some of the points in reply, but I do want to touch on some of them, if I may, before doing so. The battle between Lord Justice Briggs and Mr Justice Voss we have dealt with in our skeleton argument, and we have critiqued the points relied upon by Lord Justice Briggs with respect and supported or endorsed by Mr Justice Knowles in our skeleton at paragraphs 52 to 58. That the short point is that the temporal limit on the application to diplomats, namely during the period that they are in the receiving state, is not applied to heads of state. A necessary modification has to be imposed there. So also it is not limited to when the diplomat is accredited to the receiving state, but operates independently of any relationship with the United Kingdom. So this, inevitably, the position of the head of state is an immunity regardless of where he is, and indeed he may never come to this country, and he may never have any involvement with this country. Whereas the provisions of the Diplomatic Privileges Act are limited to the circumstances in which a diplomat is present within this jurisdiction and has professional commercial dealings within this jurisdiction.
Yeah.
And it is, we would say, somewhat incoherent for the Diplomatic Privileges Act to be applied to heads of state, given what else is disapplied in relation to the Diplomatic Privileges Act, without also disapplying the territorial limitations of commercial activity in the receiving state, which is a concept which is, as I say, overridden in every other aspect when applied to heads of state, and difficult to define as a concept, because in relation to a head of state, there is no receiving state for the purposes of the Diplomatic Privileges Act. The main thrust of the respondent's position appears from their skeleton to be that there was a pre-existing exemption for heads of state in customary international law that was all-encompassing and complete. We say that's flawed on multiple levels. First of all, as Mr Justice Voss rightly stated in Apex, there was no such customary established position in respect of all activity in the civil context. And I need to sensibly take the court to this. The State Immunity Act is at tab 3 of our first bundle of authorities. And part 1 is proceedings by or against other states. And that begins obviously on the first page. And then part 2, which begins on 46, deals with something we're not concerned with. And part 3, page 48, is the miscellaneous and supplementary, under which heads of state come into the equation. And that's where you get the application subject to any necessary modifications of the Diplomatic Privileges Act. And you see that it's a wide application. It's the sovereign. It's also members of his family forming part of his household, and in language relevant at the time, his private servants, as it applies to the head of a diplomatic mission. And so that is where the protection comes from. But it is interesting in this context to note, in the context of a state, that if you go back to section 3 at page 37, you see in relation to a state that a state is not immune as respects proceedings relating to a commercial transaction entered into by the state, or an obligation of the state which by virtue of a contract falls to be performed wholly or partly in the United Kingdom. So then you get the definition of a commercial transaction. So oddly, we say for the respondent's approach, the state doesn't have immunity in relation to commercial transactions, but it is suggested that a head of state, whose immunity after all is merely an emanation of the fact that he embodies the state, that immunity in the case of a head of state goes far beyond what apparently the state enjoys on the respondent's argument. We say that's a very odd and unlikely outcome. The reality, we say, is that if Parliament had intended the head of state to have complete immunity, it could have simply said so. But it didn't. Instead, it applied the immunity of diplomats through the Diplomatic Privileges Act route, And that is not an absolute privilege. That is not an absolute immunity.
No.
And therefore it is, you cannot start with the presumption that Parliament must have intended to give a complete immunity to the head of state in all matters criminal and civil. And it is very different when one's dealing with the criminal side. When one's talking about physical interference with the person, with the movement of the head of state, that is undoubtedly dealt with differently under the regime. But it is clear that by the time this act was brought into place, there was no assumption or theory or generally accepted procedure, and certainly the parliamentary draftsmen weren't proceeding on the basis that there was an unlimited and absolute immunity to states or heads of states or diplomats. And so you cannot start with the assumption that it must be for some reason a complete immunity. It is a more limited immunity.
Yeah.
And the question is, how do you sensibly adapt the terms of the Diplomatic Privileges Act to be applicable to the terms of the head of state? I want to touch briefly, if I may, on the case of Re Al M, which was extensively referred to below. It's in our authorities bundle at bundle 3, tab 26. The main point about it, though, and I don't want to take too long on it, is it distinguishes very clearly the position as to the criminal context as distinct from the civil context. And if your lordships have that at bundle 3, tab 26.
Yeah.
The particular paragraphs which I would invite your lordships to have regard begin at paragraph 46. After the reciting at length the submissions of the two parties in relation to the applicability of
Sorry, paragraph 46.
46 on page 924.
Yeah.
It distinguishes the arrest warrant case in the ICJ on the basis that that was a criminal case. And then it's firmly established that civil and criminal, there is some immunity, enjoys immunities from jurisdiction, but as the President pointed out, it's not enough for the father to establish that he's entitled to some immunity.
So sorry, which?
I'm sorry, we're now on to
paragraph
47.
Yes, I found it.
I'm so sorry, halfway down.
Yeah.
He would have to go further and establish the scope of that immunity, and in particular that it extends to immunity from jurisdiction in civil claims in respect of non-official acts, and that it applies even when not visiting the country. The ICJ did not need or purport to resolve those issues, nor does the comparison drawn by the ICJ with diplomatic and consular agents provide the answer, because their immunity is different from that of a head of a state, head of government, Minister of Foreign Affairs, and so on. And in the last sentence of that paragraph, 48, there can be no automatic assumption that a head of government is entitled in every foreign state to immunities of precisely the same scope as are accorded by the receiving state to the head of a diplomatic mission while posted in that state. And part of this is dealing with the fact that you have the head of state's immunity dealt with under the State Immunity Act, because he's an emanation of the state and he's dealt with under that. There is also, in customary international law, some measure of immunity accorded to heads of government, foreign ministers. That is a matter which is dealt with separately. But what is clear from all of these authorities is that you cannot deduce effectively a sort of universal principle. There is total immunity in relation to all matters criminal and civil. You have to look at the particular context and the particular way it's been provided for. And we said that the particular way it's been provided for under the State Immunity Act is that the head of state gets and gets no more than the immunity of the diplomat under the Diplomatic Privileges Act, And in order to carry that across, there have to be some modifications to the language to make the whole thing make sense.
But
And
this case isn't dealing with that issue, is it?
it's not, it's differentiating and just demonstrating that there isn't this blanket immunity, because the approach that the respondents effectively seem to take in their skeleton argument is that actually, and they seem to go as far as to say that the head of state should be accorded a complete criminal and civil immunity. If they derogate from that, it's quite difficult to see where and how they do so, but once they start to derogate from that, then they have to accept that there are limitations on the extent of that immunity. And then you get into the question, which is the battle between Mr Justice Voss and Lord Justice Briggs as to where the limit of it is.
Yeah.
Similarly, they point out that Djibouti and France was again concerned with criminal matters, not civil. At 52, the materials we've seen demonstrate a marked lack of consensus on 3 critical points.
Yeah.
Firstly, whether a head of government enjoys the same immunities as a head of state. And it refers to Lord Millett's distinction being drawn between heads of state and heads of government in Pinochet. Secondly, whether the immunity enjoyed by a head of state or head of government from civil jurisdiction extends to claims in respect of non-official acts. So that there is a clear uncertainty as to the customary international law, and therefore you cannot start with your construction of the State Immunity Act on the premise that there is some established, I'm sorry, my lord, I'm reading from page 926.
926, thank you, I couldn't.
Paragraph 52,
Yes, thank you.
identifying the lack of consensus. And then he establishes the father not established the existence of customary international law conferring immunity from civil jurisdiction on heads of government in respect of non-official acts. But it's all part and parcel of a discussion more generally in relation to the lack of a consensus, which extends more widely in relation to that. So the other reason I must refer to that, there is criticism of my predecessor for not drawing your attention to Mr Justice Knowles' attention to the Court of Appeal decision in that case. For completeness, the Court of Appeal decision was a permission to appeal judgment. The practice direction is very clear that you do not cite permission to appeal judgments. And so he didn't. And so with respect...
It did go to the Court of Appeal.
On permission to appeal and was
The
refused.
case went to the Court of Appeal.
On permission to appeal, and permission to appeal was refused.
On that, not this bit of it.
Not this bit of it.
I was in the Court of Appeal which dealt with one of the appeals, but it wasn't this one. It wasn't on recollection. It didn't deal with state immunity.
Yes, it was a different element of it. We have the decision of the Court of Appeal.
The PTA decision.
The PTA decition at tab 27 in
Lord Justice Dingerman's. I think,
4,
yeah.
exactly, my lord, and supported by Lord Justice Moylan. And it's not clear to me, in any event, what Mr Justice Knowles would have got from that had he been showed it, but in fairness to my predecessor, it's not, with respect to fair criticism of him for not having raised it. The Pinochet case has multiple differing views. There is we could take hours looking at the Pinochet case, but I don't anticipate. I'd rather deal with it in reply if there's some particular point.
If there's any particular point that arises.
And as I say, it's essentially dealing with the scope of criminal immunity, not civil immunity, let alone the extent of the commercial professional exception. Yeah. There is reason 7 of the respondent's notice is a reference to section 1(2) of the State Immunity Act. This is something which I anticipate I may be able to take very quickly, given the participation of two of your lordships in the Zhongshan case. Going back to the State Immunity Act, tab 3 of our first volume, if your lordships look at page 36,
Yes.
there is stated to be a general immunity from jurisdiction, and under section 1(2), a court shall give effect to the immunity conferred by this section, even though the state does not appear in the proceedings in question. And the position seems to be being advanced on behalf of the respondent in reason 7 of his notice, that this court is required to give effect to the immunity, even if that immunity has been lost. So in effect, it appears to be saying, even if you're with me, that the service was effected in October 2021, nevertheless, this court must give effect to section 1(2) if in fact there is sovereign immunity and cannot allow the proceedings to continue. We struggle to see how that can work. If the method of service was permitted by English law, then the respondent has been properly served. The fact that he chose to ignore it until too late is his issue, not my client's or the court's. If conversely the method of service was not permitted by English law, then the point does not arise anyway. And ultimately, we say it was correctly addressed in the Zhongshan case, which we have in our bundles at bundle 4, tab 29. And effectively, there were, it may be said, a lot of missed opportunities in that case for points to be taken, and there were questions about waivers and so on and so forth. But the basic principle which is important from that case is that which begins to be discussed at paragraph 33 on page 1019, where the court said the suggestion that it was somehow open to Nigeria to fail to comply with or disregard the timetable, but the court would still have to make a determination as to state immunity, is as startling as it is misconceived. Although if state immunity is established, the court has no jurisdiction. In relation to the prior determination of whether state immunity arises at all, the court does have jurisdiction. And then at 34, that jurisdiction must encompass the imposition of whatever procedural rules are appropriate for that determination. And this is clear from the judgment of Lord Justice Carr in J.H. Rayner, being determined in whatever form and by whatever procedure the court may consider appropriate. In the present case, Nigeria was given 2 months and 14 days. If Nigeria needed more time, it was incumbent upon it to make an application. If such an application was not made in time, then Nigeria would need to seek relief from sanctions. And if it could not satisfy the Denton criteria, then the sanction of not obtaining an extension of time would follow, so that Nigeria could not raise state immunity because it was too late. There is nothing in the CPR or the authorities which suggests that these normal procedural consequences do not follow merely because the defendant is a state. And so again in paragraph 35, about halfway down that paragraph, the sentence beginning, the proposition that even in a case where the state did not make any application to set aside the enforcement order, the court would need to make some form of further determination that state immunity did not apply on the balance of probabilities is pointless and absurd. Nothing in the authorities points to some such formalistic requirement. And the matter was then further considered both in paragraphs 38 and 40. But to pick up that principle and apply it to the facts of this case, there is, in front of Mrs. Justice Cockerell, an analysis by the court of whether sovereign immunity attaches. At that stage, the judge considered the issue, and she determined, admittedly in accordance with the procedure applicable at that stage, that the sovereign immunity would not represent a defence, but obviously that is a matter on which the respondent is entitled to come back to the court and to raise its argument in relation to sovereign immunity. Now, what then happens is, 2 years later, it comes before the court in front of Mr. Justice Knowles. On any view, the respondent is out of time under our procedural rules if service was effective in October 2021. What is the appropriate route then? Is the respondent denied of a remedy? No. He applies for relief from sanctions. He has ignored these proceedings since October 2021, and so he follows the procedure of this court, makes the appropriate application to make his immunity challenge out of time. And that is the proper procedure. The respondent hasn't done that. So he can't complain that this court hasn't, of its own motion somehow, cast aside its procedural rules and simply says, well, I'm still going to consider section 1(2) at this stage, regardless of whether there's
made in paragraph 37 of the judgment in Zong Chang, isn't it?
Exactly. So,
if you're out of time, you have to make an application for an extension of time and obtain relief from sanctions. And if
yes.
you don't do that, well, you're out.
Yes.
Even
It's
from
not
a state.
It's not failing. It's not the court failing to give effect to section 1(2) of the Sovereign Immunity Act, State Immunity Act. On the contrary, there is a procedure by which the court can, and in this case, the court has, because there was the initial assessment by Mrs. Justice Cockerell, and there was procedure by which the respondent could, and if he wanted to, should have challenged that preliminary decision in relation to sovereign immunity on the part of Mr. Justice Cockerell. And if now the respondent has lost the opportunity to raise that, that is not because of a failure of the court under section 1(2), it's the failure of the respondent to operate the procedures of the court to come before the court in the appropriate manner to have that further determined. The points that are raised in relation to, there are some further points raised in the respondent's skeleton at paragraph 71 to 76, which we say are not covered by any respondent's notice. Essentially, the points addressed there were dealt with below and fully argued, and I could, of course, were they properly before the court on a respondent's notice, have the material before the court in order to show the relevant bits of the transcript and the relevant arguments in relation to that. This is, in summary, the whole question of the exception for professional and commercial activity, which is contained in the Diplomatic Privileges Act, which we say is part, or except, is part of what is carried over by section 20, subsection 1 of the State Immunity Act to the position of a head of state. And there was debate before His Lordship as to whether we came within the professional and commercial exceptions. Mr. Justice Knowles did not, was not persuaded by that. It was dealt with fully below, as I say, and the question is, we say, very simple, that it's not a matter that's open to the respondents in this court to reopen in this way. We also say, of course, that they're fundamentally wrong about it, and they seek to argue, in effect, perhaps some sort of putting it in up there at the end as some sort of floodgates argument that somehow if this all applied in the way that we say it would apply, there would be fearful consequences for all sorts of things. Amongst the arguments they run, it appears, is that politics is not a profession. As discussed before, Mr Justice Knowles, the Oxford English Dictionary begs to differ, and the short point is that a campaign to obtain political office and the funding of a campaign for political office is all part and parcel of the role and activities of a professional politician, and it is clearly carried out outside of his official functions. It's very important to bear in mind which official functions we are concerned with at this stage. The official functions are his official functions as head of state, because that is the basis upon which he claims immunity. In fact, whether or not he was performing official functions when he was Minister of Defence would actually be neither here nor there. But anyway, it's academic. The short point is that he is, that the claims against him are wrapped up with, in part at least, the campaign contribution representations that we can and should, according to the respondent at the time, make contributions, properly make contributions to his campaign contribution. We did so, and the claim is essentially that if the Republic establishes that we were not entitled in the proceedings which have been going on last autumn properly under Mozambique, and or for that matter, if applicable, English law, to make such campaign contributions in relation to the Minister of Defence, the Minister of Finance in his campaign, then we were told that we could. And in those circumstances, we say that he is acting as a professional politician at the time, and we're entitled to proceed against him, and he doesn't get the benefit of the immunity because it's within the exception in the Diplomatic Privileges Act in relation to that. I have almost, but not quite, finished, if that's a convenient moment.
Very well. 2 o'clock. Thank you.
No worries.